This presentation is from Tan Law Solicitors. We can be contacted on 00-442-47763-3-3 or email info@tanlaw.co.uk. Please subscribe to our YouTube channel for more information. Discipline. Keys to handling disciplinary issues in the workplace. Establish the facts of each case. It is important to carry out necessary investigations of potential disciplinary matters without unreasonable delay to establish the facts of the case. In some cases, this will require the holding of an investigatory meeting with the employee before proceeding to any disciplinary hearing. In others, the investigatory stage will be the collation of evidence by the employer for use at any disciplinary hearing. In misconduct cases, where practicable, different people should carry out the investigation and disciplinary hearing. If there is an investigatory meeting, this should not by itself result in any disciplinary action. Although there is no statutory right for an employee to be accompanied at a formal investigatory meeting, such a right may be allowed under an employer's own procedure. In cases where a period of suspension with pay is considered necessary, this period should be as brief as possible, should be kept under review, and it should be made clear that this suspension is not considered a disciplinary action. Inform the employee of the problem. If it is decided that there is a disciplinary case to answer, the employee should be notified of this in writing. This notification should contain sufficient information about the alleged misconduct or poor performance and its possible consequences to enable the employee to prepare to answer the case at a disciplinary meeting. It would normally be appropriate to provide copies of any written evidence, which may include any witness statements, with the notification. The notification should also give details of the time and venue for the disciplinary meeting and advise the employee of their right to be accompanied at the meeting. Hold a meeting with the employee to discuss the problem. The meeting should be held without unreasonable delay whilst allowing the employee reasonable time to prepare their case. Employers and employees and their companions should make every effort to attend the meeting. At the meeting, the employer should explain the complaint against the employee and go through the evidence that has been gathered. The employee should be allowed to set out their case and answer any allegations that have been made. The employee should also be given a reasonable opportunity to ask questions, present evidence, and call relevant witnesses. They should also be given an opportunity to raise points about any information provided by witnesses. Where an employer or employee intends to call relevant witnesses, they should give advance notice that they intend to do this. Allow the employee to be accompanied at the meeting. Workers have a statutory right to be accompanied by a companion where the disciplinary meeting could result in a formal warning being issued, or the taking of some other disciplinary action, the confirmation of a warning, or some other disciplinary act. The statutory right is to be accompanied by a fellow worker, a trade union representative, or an official employed by a trade union. A trade union representative who is not an employed official must have been certified by their union as being competent to accompany a worker. Employers must agree to a worker's request to be accompanied by any companion from one of these categories. Workers may also alter their choice of companion if they wish. As a matter of good practice, in making their choice, workers should bear in mind the practicalities of the arrangements. For instance, a worker may choose to be accompanied by a companion who is suitable, willing, and available on site, rather than someone from a geographically remote location. To exercise the statutory right to be accompanied, workers must make a reasonable request. What is reasonable will depend on the circumstances of each individual case. A request to be accompanied does not have to be in writing or within a certain time frame. However, a worker should provide enough time for the employer to deal with the companion's attendance at the meeting. Workers should also consider how they make their request so that it is clearly understood. For instance, by letting the employer know in advance the name of the companion, where possible, and whether they are a fellow worker or trade union official or representative. If a worker's chosen companion will not be available at the time proposed for the hearing by the employer must postpone the hearing to a time proposed by the worker, provided that the alternative time is both reasonable and not more than 5 working days after the date originally proposed. The companion should be allowed to address the hearing to put and sum up the worker's case, respond on behalf of the worker to any views expressed at the meeting, and confer with the worker during the hearing. The companion then does not, however, have the right to answer questions on the worker's behalf, address the hearing if the worker does not wish it, or prevent the employer from explaining their case. Decide on appropriate action. After the meeting, decide whether or not disciplinary or any other action is justified and inform the employee accordingly in writing. Where misconduct is confirmed or the employee is found to be performing unsatisfactorily, it is usual to give the employee a written warning. A further act of misconduct or failure to improve performance within a set period would normally result in a final written warning. If an employee's first misconduct or unsatisfactory performance is sufficiently serious, it may be appropriate to move directly to a final written warning. This might occur where the employee's actions have had, or are liable to have, a serious or harmful impact on the organization. A first or final written warning should set out the nature of the misconduct or poor performance and the change in behavior or improvement in performance required with time scale. The employee should be told how long the warning will remain current. The employee should be informed of the consequences of further misconduct or failure to improve performance within the set period following a final warning. For instance, that it may result in dismissal or some other contractual penalty, such as demotion or loss of seniority. A decision to dismiss should only be taken by a manager who has the authority to do so. The employee should be informed as soon as possible of the reasons for the dismissal, the date on which the employment contract will end, the appropriate period of notice, and their right of appeal. Some acts, termed gross misconduct, are so serious in themselves or have such serious consequences that they may call for dismissal without notice for a first offense. But a fair disciplinary process should always be followed before dismissing for gross misconduct. Disciplinary rules should give examples of acts which the employer regards as acts of gross misconduct. These may vary according to the nature of the organization and what it does, but might include things such as theft or fraud, physical violence, gross negligence, or serious insubordination. Where an employee is persistently unable or unwilling to attend a disciplinary meeting without good cause, the employer should make a decision on the evidence available. Provide employees with an opportunity to appeal. Where an employee feels that disciplinary action taken against them is wrong or unjust, they should appeal against the decision. Appeals should be heard without unreasonable delay and ideally at an agreed time and place. Employees should let employers know the grounds for their appeal in writing. The appeal should be dealt with impartially and, wherever possible, by a manager who has not previously been involved in the case. Workers have a statutory right to be accompanied at appeal hearings. Employees should be informed in writing of the results of the appeal hearing as soon as possible. Special cases where disciplinary action is being considered against an employee who is a trade union representative, the normal disciplinary procedure should be followed, depending on the circumstances. However, it is advisable to discuss the matter at an early stage with an official employed by the union, after obtaining the employee's agreement. If an employee is charged with or convicted of a criminal offense, this is not normally in itself reason for disciplinary action. Consideration needs to be given to what effect the charge or conviction has on the employee's suitability to do the job and their relationship with their employer, work colleagues, and customers. For more information, contact 10 Law Solicitors on 0-47763-323. Email info@tanlaw.co.uk or WhatsApp 0791 507 0549.